So welcome everyone to today's session on choreographic attunements in the legal humanities with Anna Jane Kimmel and Juan Manuel Aldape Muñoz. I will introduce both of the speakers now, and so Anna will go first, and then we'll hear from Juan. Anna Jane Kimmel is assistant professor of dance at George Washington University. She also pursues community-engaged research in carceral studies, fostering collaboration with artists in confinement and serving as a restorative justice facilitator for alternative accountability programs. Her scholarship appears in Dance Research Journal, Performance Research, Lateral, the Drama Review, and the Brooklyn Rail, as well as various edited volumes. She serves on the board of Performance Studies International and is an associate editor for Performance Research, and is co-editor of a forthcoming collection of essays on law and performance that will come out from Routledge this year or next. Juan Manuel Aldape Muñoz is assistant professor at Cornell, Department of Performing and Media Arts, with a research and artistic focus on the intersection of performance and dance studies, Latina, Latine, Latinx studies, and undocumented cultural production. He was the 2024 Maggie Alesi National Center for Choreography Embedded Writer Fellow and Artist in Residence. He's the former managing director of San Francisco's Festival of Latin American Contemporary Choreographers, and his writing can be found in Performance Philosophy, Theater Research International, Dance Research Journal, and other publications. Thanks so much to both of you for sharing your research today. Anna, please take it away.
Thank you so much. I'm going to go ahead and share my screen, so give me 30 seconds while I refamiliarize myself with Zoom in a more fully post-COVID moment. Let's see here. Is this available to everyone? Great.
Perfect.
Okay, then thank you so much for the invitation. I'm genuinely so excited for today's conversation to be in dialogue. And so I've really tried to frame my remarks as more an opening for generative conversation, including the students in the room, rather than a more hermetically sealed argument or a didactic presentation. I should begin by naming, however, that I'm here as a performance studies scholar and an assistant professor of dance, which is to say I come from a field of the humanities that from its incarnation itself is a space of interdisciplinary methods and unruly standard. It's a field that centers live performance, which is to say the ephemeral, as its object of analysis and address, or as dance critics have written, that contemporary fleeting moment that exists at the vanishing point. This is all to say that I enter a conversation in the legal humanities with its center of law and literature, predisposed to be skeptical of the absence of the body, of the foregone conclusion that legal interpretation is necessarily or exclusively textual. So at the suggestion of Juan Manuel today, I want to think through this orientation in terms of legal kinesthesia, what I define as the bodily sensations through which institutional and juridical norms can be felt, known, interrogated, and maybe even reimagined. My intention is to move through 3 related case studies that I'm currently working with as potential nodes for post-presentation conversation and activation together. I really invite you to think with me on this. But first, 2 points of entry into this conversation. I currently live in Washington, D.C., and there the National Museum of the American Indian has a striking installation. A mural reads that we are the evidence. And so today I want to ask, what if we took this assertion seriously, as more than metaphor? If we understood this claim as an intervention to legal interpretation as we understand it, that the body and its kinesthetic memory retains an afterlife of law, and to offer as a potential well from which we might reconsider legal conclusions. To summarize the necessity of this argument, I want to offer a second point of entry in today's conversation. Recall the infamous words of Justice Potter Stewart, who writes, "I know it when I see it," used to define his test for obscenity. Now near parody and well-cited, this statement reveals many things to me. 1, that textualism, based on intent or otherwise, would be fruitless here, because even legal language can be profoundly vague and abstract. In this instance, the abstraction of the pronoun it leads to the incredible ambiguity twice over in one sentence. This statement also suggests that legal texts are especially prone to shortcomings when addressing concerns of the ephemeral or corporeal, in this case, obscenity law. The justice does not seem equipped with the necessary vocabulary to meaningfully discuss the body in action, in spite of robust literatures elsewhere. And third, even Justice Stewart subconsciously acknowledges that his process of rational interpretation involves the phenomenological. Here, the sense of sight and ocular processes of recognition that exceed language produce legally verifiable information. I know it when I see it. Taken seriously, the phrase suggests that legally relevant knowledge is contained in the extraliterary, or paratext, what I point to as the embodied, the gestural, the performative, and what Juan Manuel would invite us to summarize as legal kinesthesia. So moving forward with these observations at hand, I want to reflect on a current project I'm working through on the right to rest, which entangles three instances of the stilled body misread under the legal gaze. I'll share them out here as very brief snapshots of a wider constellate, as I imagine a choreographic attunements to be meaningful in spaces of law. So specifically, I want to begin with case study 1, which centers recent attention towards anti-homelessness laws, with particular attention towards the moving target of Eighth Amendment protections. Case study 2 will look at precedent cases of anti-loitering laws in which vagueness permits slippage between status and conduct. In case study 3, we'll shift towards encampment policies during university protests. If these three topics have individually received address by legal scholars, practitioners, and activists alike, they're not often understood as constellants of a wider pattern of legal thought, where movement and stillness become glossed as productive or unproductive to the social good. So toward an otherwise, I'll wrap up my comments by offering two distinct artistic works as spaces of alternative valorizations of rest. So as you may recall, when the U.S. Supreme Court held its ruling in 2024 of Grants Pass v. Johnson, that the enforcement of laws which regulate camping on public property does not violate Eighth Amendment protections against cruel and unusual punishment, the response was varied and polarized. This opinion reversed and remanded a previous decision, such that the right to sleep in public spaces became a criminalizable act. In particular, it reversed the Ninth Circuit's ruling in Martin v. Boise, which bars cities from enforcing public camping ordinances like these against homeless individuals, whenever the number of homeless individuals in a jurisdiction exceeds the number of practically available shelter beds. The attention here to practically available beds creates an amorphous algebra between the homeless population, shelter capacity, and the category of involuntary homelessness. In practice, it endorses the power to sweep encampments, language which facilitates a sanitization of the body as object, to be moved or displaced, with implications for city planning, public health management, and human rights discourse. The narrative thus framed suggests one of divergent views of safety and care, in which attention and responsibility oscillates in tension between the rights of the unhoused and the community population more broadly. But I want to draw attention to a more fundamental grievance revealed by this recent ruling, namely a permission to corporeal ambiguity that saturates a modern legal thought, especially in legal orientations towards the resting body. By naming corporeal ambiguities, I aim to draw attention to the slippage in the rigor and objectivity of legal interpretation, when the body and its gestures become the central concern. The Roberts Court acknowledges this ambiguity outright. There is uncertainty, writes the majority, over whether Martin requires cities to tolerate other acts no less attendant to survival than sleeping, such as starting fires to cook food and public urination and defecation. By extending Robinson beyond the narrow class of status crimes, the Ninth Circuit has created a right that has proven impossible for judges to delineate, except by fiat. But what is so impossible about objectively viewing the public body? And why must discernments of gesture, action, and conduct be so arbitrary when there exist in other fields more robust methodologies and language? So as I'll argue, this negligence towards corporeal specificity is particularly replete within legal attentions that criminalize rest, sleep, stillness, or otherwise. When the bodies and its gestures go missing from more nuanced attention in legal interpretation, bias, prejudice, and discrimination have opportune to sleep in. As Walter Benjamin reminds us in his reflections on legal violence, Anatole France satirically penned that poor and rich are equally forbidden to spend the night under the bridge, but only some might be punished. Consider the following excerpt from the dissent in Grants Pass. The majority proclaims that it makes no difference whether the charged defendant is homeless, a backpacker on vacation, or a student who abandons his dorm room. that describes a fantasy. In reality, officers testified that laying on a blanket in the park would not violate the ordinances, that sleeping on a sleeping bag to look at stars would not be punished. Instead, one violates the ordinance only if he or she does not have another home to go to. That is the definition of being homeless. If stargazing here feels disingenuous, I do wonder, where do you draw the line? More important to me, how do you? Hyperbole surfaces the problem. If one is not permitted to sleep, what about to nap? To blink? For how long can one close one's eyes? Taken to an extreme might sound funny, but ambiguity emerges somewhere between awake and asleep. Moreover, precedent cases referenced in Grants Pass conflate homelessness with narcotic or addiction and alcoholism in a phobic casting of the unhoused body as abject, diseased, or otherwise unwell. And I want to caution against the conflation of illness, poverty, and addiction that this history of anti-homelessness laws unwittingly presents. Through both cases and others, the socially ailed body is conflated with the medically ailed. This slippage confounds biopolitical matters and humanitarian responses, and the socially ailed body requires more than prescription for healing, and when presented as sick, is unwillfully and wrongfully framed as contagious. The parallelism invites further slippage between the language of the marginalized and the quarantined. The resting body, sleeping and or camping in public, or something else, could alternatively signal virtue, regrowth, futurity. It might instead suggest prosperity, healing, or reclamation for life-sustaining conduct. Others elsewhere are quick to have this predisposition, an alternative association and appreciation for the body at rest that does not conjure attitudes of disgust. Bell Hooks, Tricia Hersey, Luke Williams, and countless more labor to share, in verse, in prose, in visual design, and performance, of that glowing reminder that at times the most amazing things come from a place of leisure. Given his preoccupation with scenes of agitation over scenes of stasis, legal theory rarely positions the still body as resting, recovering, or rejuvenating, three states of being which are undeniably productive if viewed at a larger scale. Rather, these vital signs are often misrecognized as mere idleness, as wasted breath, and as dangerous potential. Injury impedes the scene, as the unhoused figure is somehow cast at once as maimed and aggressive. The kinetic project of modernity, though, defined within an aesthetics of dance, extends to the state and its legal arms, as bodies are kept in perpetual motion in the name of labor, productivity, and capital gain. Keep moving becomes the refrain, as the unproductive body is always out of place. It's all too easy to point to the blossoming sector of active design and its subgenre of hostile architecture as examples, with benches and armrests purposely designed to prevent lying down. This perpetuation of the body in motion has generated momentum in the call for the right to rest. Jonathan Goldberg Hiller frames it bluntly: is a right to sleep so inconceivable? For him and others, this question challenges the relationship between the night and its insecurities, linking sleep, sovereignty, and vigilance. Thinking alongside this tradition, I'm also interested in the biopolitics of the right to sleep and what might be revealed by the value of rest, sleep or otherwise, in which the idle body is coded as antagonistic with productivity. As referenced above, Grants Pass signals a shift in the legal attitudes towards the public body at rest. The shift suggests not only new attitudes of visible homelessness, in which sleeping outdoors becomes recriminalized, but also redrawn interpretations of Eighth Amendment and its corporeal protections. Rather than dispute this decision, though in a longer version I do, however, today I want to consider the corporeal assumptions and oversights sewn into the sentiment. In arguing that the punishments for sweeping encampments and other move-along orders do not violate Eighth Amendment protections against cruel and unusual punishment, judges in Grants Pass cite relevant fines for first-time offenders and limited jail time for repeat offenders as punishments which do not qualify for cruel because they're not designed to superadd terror, pain, or disgrace. While the justices effectively argue that a minor fine or jail time for a repeated infraction do not seem to rise to the level of terror or pain, this consideration further omits an a priori event, in which the actor's sleep is interrupted in order to receive notice of the violation. The punishment extends then from the overtly named consequences of fines and potential incarceration to the implicit policy of sleep deprivation in the moment of disruption itself. But interference with sleep can be particularly terrorizing, with sleep deprivation as a known strategy of military intelligence. Rest extends then beyond a metaphor for me. Rather, the scientific impact of sleep deprivation extends wide and deep. Biomechanical metrics of heart rate, lifespan, blood pressure, immunodeficiency, and more reveal the all too real impact of legal codes on the body itself, not only on its access to personhood. When legal kinesthesia motivates review, there's shallow engagement with the body as both a corporeal sign, where aesthetics and grace and dignity cohere, and as biopolitical matter, wherein disruption of sleep has a profound and medical impact. Moving to case study 2. The corporeal ambiguities outlined above in relation to anti-homelessness laws follows a lot wider legal tradition in which the resting body moves uneasily under legal gaze. Vagrancy, a catch-all for the out-of-place body, has long centered performance in its ephemeral ambiguity. Recall that loitering laws restricted the presence of the body for extended duration without clear purpose. This definition thus acknowledges and presumes the ambiguity of the corporeal, while nevertheless seeking to delimit it. Without clear purpose, on the one hand, suggests that the existence of purpose itself is not enough. Rather, it must be rendered visible and legible to the onlooking public. This reading of visible returns us to the question of the aesthetic valence of law, as it relates to the body and its resultant ambiguities. Vagueness becomes a critical term here, akin to the wider critique of corporeal ambiguity I suggest here today. In Chicago, for example, loitering laws once policed those who remain in any one place with no apparent purpose. A 1999 Supreme Court decision, however, ruled that this language was unconstitutionally vague. By 2000, the city of Chicago had revised its ordinance to define loitering sans ambiguity as remaining in place under circumstances that would warrant a reasonable person to believe that the purpose or effect of that behavior is to enable a criminal street gang to establish control over the identifiable areas, to intimidate others from entering those areas, or to conceal illegal activities. The word count proliferated, but I'm not sure that clarity did too. The introduced verbs of control, intimidate, and conceal hardly describe conduct, but rather ambiguate forecasted action. One might also point to the infamous walking while trans ban and other related discriminatory practices, wherein vagueness and corporeal ambiguity emerge for the idle person. As a reminder, Penal Law 24037 criminalizes loitering for the intent of prostitution in the state of New York. As NYCLU notes, however, for decades this law was used against innocuous behavior, quote, like waiting for a friend or waving down a taxi. The ready shift between these verbs, walking, loitering, waiting, waving, is precisely the point, as law and law enforcement allow slippage and conflation between these choreographic differences. Conduct again seems to take a secondary measure to status, as it is not just the actions under question, but the person performing the act as illegal. Beneath the surface of anti-loitering laws and their related vagueness towards the idle body simmers assumptions of idleness with unproductivity. Loitering and idling, after all, are often defined against the litmus test of purpose or object, a reason of being deemed worthy by society, or at least the onlooking authority. But such righteous language of purpose veers into expressions of value and uncomfortable arithmetic of human life all too familiar in this neoliberal era. While there may be less productive ways of passing the time, idleness for its own sake can have immense value. The Pomodoro method, the 4-hour work days, the 4-day work week, and other self-help guides to productivity through strategic rest, ironically name this in terms of output. But this known fact of the workplace evaporates before anti-loitering laws as purpose and object are required to be clear. Rest for rest's sake, rest for future productivity's sake, seems illegible under legal theory for being still in the eyes of the court. Moving to case study 3. As Grants Pass played out in the U.S. Supreme Court in the summer of 2024, a twin narrative unfolded, namely the emergence of university encampments in response to violence in Gaza and the subsequent dissolution of encampments. In many of these instances, student arrest and dispersion occurred in the dead of the night as students slept. Rest was once again criminalized, and the still body, even here the sleeping body, was disrupted by legal force. Although a different form of encampment than unhoused, featuring a different cause and different demographic, similar patterns and rhetoric emerge in their treatment. As Grants Pass reinstalled police with the legal authority to sweep unhoused encampments for the sake of public safety, so too did many universities decide to forcibly disrupt and dispel the student protests. This parallel between campus activism and unsheltered treatment is not new. With uncanny clairvoyance, Risa Goluboff writes that what was happening in college campuses turned out not to look different from what was happening on the inner city streets, in reference to anti-1960s anti-war protest in the US. But for today's conversation on choreographic attunements to law, I want to make a new parallel. That there's an uncanny similarity between encampment as noun and performance studies as method. An intersection of temporal fleetingness and physical imprint, an encampment exists only to disappear, occupying a presence on the precipice of erasure. Dance and performance too exist at that perpetual vanishing point, and its etudes are a constant effort of theorizing, documenting, and recovering this intrinsic ephemerality. Encampment, then, like performance, is marked by its impermanence, placed but in motion and already on the move. In its second definition, encampment refers to the bodies themselves who gather to camp. The term in turn names and thus visibilizes a population, and by extension a crisis, including the case of homelessness. But for vulnerable populations, such visibility carries a risk, as the politics of performance remind us of the stakes of remaining unmarked. Yet the congressional hearings on university protests and pro-Palestinian encampments primarily focused on addressing issues related to free speech, campus activism, and the actions of universities in response to political demonstrations. While this is a valid and necessary debate which continues to require ongoing dialogue and review, the attention to free speech contradicts the reason for which most students were arrested, namely trespassing. Additional charges feature the corporeal, disorderly conduct, failure to disperse, resisting arrest, obstructing justice. The emergence of trespassing enforcement as the de facto infraction by university campuses names the student body as out of place on university campuses. If status has previously been parsed from conduct, there arrives then a new injunction, status not scrutinized by conduct, but by presence, or what we might term overpresence. The conflation between speech and action here mirrors the conflation that takes place in the right to assembly with the right to free speech as well, written about previously by myself and others. In spite of the clear spatial and kinetic features of the encampments, many media outlets, institutional affiliates, and state authorities from all sides of the political spectrum analyze the events with particular scrutiny of free speech. This includes related verbiage of protecting the broadest possible latitude to speak, write, listen, challenge, and learn. Such attentions to encampments as free speech efforts fundamentally mischaracterizes the term, however, suggesting that linguistic expression reflects the normative and ontological intent and performance of the encampment. The body again slips in and out of view, overrepresented in the physical assault of the police encounter and its related charges, yet underrepresented in the political and legal debates surrounding the events. Against the prohibition of the idle body in each of these three scenarios, rest emerges as a strategy of resistance. So by means of conclusion, I want to turn towards two artistic works which influence my thinking on the right to rest. Briefly, in Black Power Naps, multimedia artist and activist Niva Costa and Fanny Sosa offer an immersive alternative in which futuristic beds crafted in neon hues and luxurious sheen shimmer with their invitation to care. Transformed and transfigured, the space as library come resting space dreamland presents a sanctuary for rest. On the floor, the installation offered its own legal code, coding refusal and rest alike as resistance. Reading out an excerpt, it says, "To the beings that come into the space, here we tell you the laws of the land. Continue to mind that the space is to be enjoyed without extracting or hurting. Leave everything intact when leaving. If you see a Black person resting, don't call the police. Never." So here, race, labor, and rest blur again in some constellation, rescripted once more as an alternative law of the land, rehearsed and enacted if nonetheless real in this performance. But more than, say, woke activist installation as it has been critiqued, this project presents an intergenerational project of redress as it choreographs invitation of rest, care, and recovery within an oppressive national legal history. It came from an understanding that the American dream is a sleepless one, so Sir said. We inherited this exhaustion. A second intervention in the form of street signs parodies the vagueness of legalese and its discretion in loitering law specifically. A series of street signs were installed across New York City in 2015 by the artistic collective Ghana Think Tank, which has been developing the first world since 2003. This organization quibs to set up laboratories in the so-called developing countries to solve first world problems, in a reversal of power dynamics that is as serious as it is outrageous. I returned to this installation, though, to draw particular attention to their legal waiting zones, in which explicit loitering zones were constructed. The permission to wait, to linger, to rest here goes against interpretation of anti-loitering laws. The sign by Ghana Think Tank does not simply designate an alternative space, here in Queens, for immigrant families, but features valid reasons for waiting, for a friend, your mom, or just because it's hot inside your apartment. In so doing, it names the reasonable intent for the idle body, which does not precipitate interpretations of violence, and challenges interpretations built on a history of racialized violence. For context, this work emerged through narratives of immigrant workers with the artist who had been ticketed for loitering, despite the fact that anti-loitering law was deemed unconstitutional in New York. The intervention was thus also an educational project produced in English and Spanish to inform community members of their rights. These cases here, from homelessness to loitering and vagrancy to encampment as protest, are divergent, nuanced, and pluralistic. Gathered together, however, they constellate to reveal a pattern of corporeal ambiguity tolerated when addressing the body at rest. In each instant I highlight, stillness is either positioned as unproductive or an anticipation of violence. But sleep is a biological necessity, as Justice Sotomayor dissents, not a crime. Stillness moves when rest is resistance, and an attunement toward legal kinesthesia might lead us to overturn foregone conclusions about the body at rest, homeless, loitering, or otherwise encamped. Thank you.
Thank you. Juan, please take it away.
Yeah, thank you. While I wrap up this presentation here, I hope everyone can see me. I just want to say it's such an honor to share this space with you, Anna, and I'm really excited to our continued conversation. I see overlaps in what we're doing as well as see divergences, and that's always where the great work happens. So I appreciate it. And thank you for the opportunity to be here today. I'm really looking forward to the percolations from of what come of this session and going forward. At the December 2019 naturalization ceremony in Oakland, California, hundreds of aspiring citizens waved and shouted and the little flags, having summited the gauntlet that is ascribed to naturalization processes in the United States. People cheered, showed excitement, they waved, they held their phones up, recording the moment, celebrating. Flags were on sale in the hallways in anticipation of the large theater. And in this moment, there was a collective effervescence, a reminder that they had summited collectively and individually what is otherwise a limited space of incorporation. Right. So the 2019 naturalization ceremony in Oakland, to me, sort of emphasizes the embodied aspects of incorporation within the legal bounds of what is a temporary community for cohabitation. But it also marks the space of difference and how difference is felt on the body, and it's expressed through moments of elation, through shouts, through joy. But it also showcases and evidences in what is not said, in the moments of pain, the moments of anguish, the moments of desperation that are left outside of the space, or rather are exposed in the space by not being included in it. So what's interesting about the 2019 ceremony in which I participated myself, having been formally undocumented in the United States and having naturalized after 22 years of living in the United States without the proper documentation, was how the kinesthetic and embodied aspects were emphasized even as they were being articulated, right? There was a moment of elation and a reminder that we were being incorporated into a felt and unified community. Now, much has been said about these conditions and much has been said about the purpose of these ceremonies, but I feel what remains under-examined is these embodied aspects, not so much in the moment, but what happens after them. So here I want to spend some time in asking questions about not so much what do we feel in the moment of becoming legible subjects before the law, but how do we feel once the law has recognized us as individuals? And so a lot of my attention has happened to be on movement and on the go. And a related question, how does the experience of the event produce meaning for social cohesion and how we understand belonging? At the center of today's talk, I have a concern with embodiment and kinesthesia, specifically as it relates to immigration laws and policies. Now, embodiment possesses different and at times competing meanings from fields as disparate as philosophy and cognitive science. And in border and immigration studies and naturalization law, the term carries an even more profound indeterminacy. But what is clear and has been made evident recently within the past week is that the term itself initiates corporeal internalization about immigration laws as carried out by immigration enforcement and normative codes of conduct for proper participation in what it gets deemed as proper citizenship, and how they leads to how we move on the go. Now, corporeal internalization and kinesthetic awareness of restricted movement, of what the law compels us to do, is the result of exaggerated production of what Guadalupe Correa Barrera and Terence M. Garrett, in linking phenomenology and performance and borderland studies, call the perception of fear and its impact on immigration enforcement and border security. So they argue that emotions and feelings such as fear, surprise, are expropriated as part of social construct for the public to lose sight of reality and how and that allow for the enactment of security industries and political interests. So despite the laws of reality, they argue, the audience, meaning those who are considered outside of the space of the law that aims to exclude, watches racialized and criminalized geographies shaped by effective maps. For example, the southern border is full of brown people and crime is rampant. I should feel afraid anytime I am close to the environment. Now, expropriation, according to them, occurs primarily through the rhetoric of fear by politicians and the security industry. Advancing Correa, Cabrera, and Garrett's argument further, for me, an attention to embodiment where immigration carries out its force allows us to apprehend to how illegalized bodies are allowed to go and what they sense in that movement. Indeed, rhetoric contributes to the perception of fear, as we have seen in the past week, and the active involvement of ICE and CBP. But so does choreographic cueing enacted to the detection of movement when no words are deployed. These conditions compel me to assess what could be called choreographic attunements to the law. Now, Cindy Garcia proposes that we understand choreography as physical and social movements shaped and informed by culturally situated corporeal meanings and codes not limited to the dance floor. Now, as the naturalization ceremony anecdote shows, orchestration of bodily movement and its carrying out is key to the effective perpetuation of power for social cohesion. Intending immigrants need to participate in the ceremonies to fulfill the contract and retain naturalization and the corporeal sense of belonging, of feeling as though you have joined what Ahmed would call a table of happiness. Now, assessing interactions between law and choreographies or to carry out choreographic attunements, however, exposes rather unexpected outcomes. So what I want to do today is spend my time looking at these unexpected outcomes when we attend to choreography, and I'm going to give a couple of examples. And I want to discuss how choreographic practices and concepts such as movement, rhythm, embodiment illuminate and interrogate the structures, practices, and ideologies of law and also the humanities. So this inquiry is significant for the legal communities because it allows us to identify the persistence of inequalities despite rhetoric and policies of immigration coming into more inclusive. This talk extends, but is not solely.
Excuse me, I'm so sorry to interrupt, but we're having some issues with your mic sounding a little bit garbled. I'm so sorry to do this. I don't know if everyone else is picking this up as well.
Oh, really? Okay.
Yeah, no, it just got better.
Is that better now?
Yeah.
Okay.
Yeah.
How much of it was omitted from the garbling?
I could hear, I just had to strain pretty hard. It felt maybe like a shirt was muffling something, but it seems good. I would just maybe be still.
Okay.
Sorry.
No, thank you for that. So what I was saying, transitioning to, is that today's talk extends from my current book project, The Alien Commons, Choreography and Performance Beyond Research, Beyond Citizenship. And I look at the work of choreographers who were formerly undocumented, currently undocumented, or who are part of mixed status families or mixed status projects. And I look and unpack what does it mean to look at specific artists who are attentive to choreography in their practice, but what they expose about the law and its meaning and how it compels individuals to move. But I actually want to start somewhere else for this specific connection as an example about the connection between the embodiment of the law and movement. For the 2018 Festival of Latin American Contemporary Choreographers, the choreographer Fabiola Guillen was invited to showcase a new work called Stabat Mater. She is a Mexican-based contemporary choreographer. Now, in my then role as curator, I invited Guillen and her outstanding company to come and participate to premiere this work in the United States. In preparation for their travel, one of their members' visas was actually denied, and they couldn't come. Now, what's interesting is that in this moment, Guillen had to decide whether she was going to cast the performance in the same vein, or if she was going to recast it. The Stabat Mater in this specific context for her represented the representation of Mary holding Jesus Christ and lamenting over his death. In response to her choreographer, her collaborator and dancer, she chose not to incorporate him or replace him, but instead chose another choreographer, a dancer from the specific piece. Now, what's interesting is that the performer originally was male presenting and was supposed to represent the male presenting aspects of Jesus Christ before Mary. But in redoing the performance, she recast one of the other members who was female presenting. And the resulting consequence was actually a female presenting, long-haired performer before Mary. In the discussion after the performance, Guillen said that this performance reshaped the immigration consequences of this specific performance shaped the meaning of it. So now Mary was no longer crying before a crucified Jesus, but rather was Mary dying before a female presenting woman, and that in fact this performance now connected to the feminicides that were occurring throughout Mexico. Now, what I find particularly interesting in this case is less the immigration, but the consequences of what immigration law does for how we encounter performance practices. And in this case, Guillen's observation that the meaning shifted has specific consequences for not only how we understand the role of immigration, but how we also understand choreographic reception of aesthetic practices. Meaning, when we watch performances, we're already watching performances mediated by how individuals enter into the space. Whether individuals possess an undocumented status, documented status, or naturalized citizens, thus who's allowed to enter and engage in aesthetics practices is already mediated by immigration law or naturalization law. Now, the other aspect that this performance highlights is the tension of what Judith Butler calls legal performativity versus bodily performativity. For Butler, the tension between legal performativity and bodily performativity is important for when we talk about cohabitation across difference. Legal performativity is those moments where we use rhetorical practices to distinguish difference and to allow us to gather and use legal mechanisms or protected civil rights for being able to articulate how we choose to be together. However, for Butler, she's compelled to understand, well, how do we work across that through difference, where either there is restrictions for what we say when we gather, or also where there is difference in terms of our ability to understand each other. So how do we relate across that difference? For Butler, bodily performativity of gathering together, of being together without having to enunciate, to be oral in the way that we articulate our difference is critical. And this tension between legal performativity and bodily performativity is certainly at the center of a lot of immigration performances. Many of the performances that I look at sort of toggle between trying to identify how much immigration policy context they provide in the moment of describing their feelings of displacement, their feelings of jubilee for having become naturalized citizens, and how much they just account to difference and use nonverbal modes of communicating those experiences. Now, this tension, rather than trying to reconcile it, to me exposes what, as Anna was saying, what I'm thinking through as we're calling legal kinesthesia. Now, much has been said about legal consciousness, and within performance studies, Gad Gutterman, looking at the experiences of undocumented theater practices, has demonstrated with great skill the way in which legal consciousness shapes how we as individuals imagine our lives and our possibilities. However, moving away from the imaginative and more to the corporeal, although they're related, I'm interested in in this experience of kinesthesia, of how the body feels as we move, and how the law shapes that movement and how we feel. In this way, also looking at Supreme Court Justice Potter Stewart, I'm interested in how we move from the "I know it when I see it" instance to rather "I know it when I feel it." How do we recognize and understand not only law differences, but the way in which law is racialized? I need only to give an example that just this past week, Puerto Rican individuals are being detained and essentially taken to detention centers merely for speaking Spanish, right? And so how do we recognize this moment of where the law gets deployed through these racial vectors and taking into account how that happens. But also from the other perspective, certainly there's a lot of grief and angst in how individuals who are negatively impacted by the current policies of enforcement and border security also limit their participation. Here locally, recently there were at least 5 different performance social gatherings for dance and music are prevalent canceled. In a Facebook response, a potential participant was glad that they canceled the social gathering and said, uh, I'd rather be caught working and deported rather than be caught dancing. So there's this tension of individuals, wanting to negotiate their sense of corporeal movement and the way in which these cognitive maps shape where and how they move. And this is particularly relevant for the abundant and growing scholarship that attends to undocumented cultural production, whether it's in the work of Andrea Almiro, who's writing as the stories of Filipina caretakers in retirement homes, working with retirees who are citizen possessing, but who are themselves deported from these care homes, or in the work of Tanya Guiniga, who is very much attentive to the way in which the law is not only internalized through the aspects of seeing or felt, but quite literally metabolized. She herself went through the southern border of dividing Tijuana and San Diego and crushed the rust and created an installation where she's actually inhaling to both demonstrate the magnitude in which we actually ingest both the law, but also the material realities that the law creates. There's no video that's coming up. Oh, there it is. Now, for me, this has specific resonances, as I said, as a formerly undocumented person. In the short film piece called Exile, I myself also work through the way in which the law shapes itself in feelings and intentionally leaving and absolving, articulating legal performativity of being intentional not to include any references to the law, but rather what the law produces, its feelings and sensations. The piece itself takes place in the Utah Salt Flats, a then growing metropolis of immigrant individuals who moved there in anticipation of the 2002 Winter Olympics, and where migrants moved there as secondary cities and the ever-growing immigrant population at that time. I myself having been a part of it. Going into the Salt Flats, creating a vast white landscape in the middle of what could appear to be nowhere, and testifying to the experience of trying to seek and find a place where one may not appear, but only following the contours of very abstract feelings, sensations, and movement. Now, this piece itself, I only recently was reacquainted with because I had transferred from DVD and VHS to the digital format, but reacquainted myself with this performance and my then aspiring career as a formerly undocumented person allowed me to attend to what I couldn't yet articulate, but nonetheless felt in that moment of isolation, of loss. And it was shortly after this piece that I decided to leave the United States undocumented, not knowing if I would be able to return. Having grown weary of the restraints that were imposed upon me and others, I decided to leave. Now, these specific examples that I give about these various performances are more testaments to the way in which the law imposes itself on individuals and how we might attend to those conditions. But there are also moments of dislodgement where if we attend to legal kinesthesia, we can see instances of possible interventions. In the Sunflower Man, Erika Miranda, who collaborated with Jose Luis Mendoza in the Niagara Falls area of Canada, she worked with immigrants or worked with immigrants who worked in the agricultural system and were recipients of temporary working visas who were arrived to Canada on a yearly basis, specifically the Niagara Falls. Now, what I find interesting, and there's a lot to unpack in this specific encounter and the way that they collaborated, but what I want to focus on the fact that Jose Mendoza and Erika Mendoza and Jose Luis were invited to showcase a duet that they created about his experiences of having lived in Canada for close to 30 years working in the sunflower field. However, in anticipation of speaking before Parliament talking about precarious work on October 10th, Jose Luis, Juan Luis' visa was about to expire and they couldn't renew it. And so Jose Luis and Erika petitioned both the Mexican consulate to extend his work visa because it was on a limited term, but they couldn't do it. And so they petitioned for him to stay a week later, not on the grounds of labor, but on the grounds of the work that he was doing through the dance, showing videos, documentation of their work together, working in the field, but also the discourses that he was building with Erika. And in the end, he was successful in getting a extended permission to stay in the country of Canada, but it wasn't through either a work visa or exceptional artist visa. It was a visitor visa. Now, I find that fascinating. The way in which he became a legible subject for an extended visa was through the language of a visitation, and he couldn't be compensated. But the compelling and forceful part of this performance to me is the way in which dance became legible before a jury of immigration officers to say this merited, but it did not enter the legal language of immigration discourse. And so I want to wrap this session up and obviously talking to Anna about these intersections, but also thinking about how performance becomes a site to enact new ways of imagining together. And in some cases, it could just be small stages for where individuals get an extra week to live in a place where they associate themselves with, but are otherwise told that they don't belong.
Well, thanks very much to both of you. So yeah, we have plenty of time for questions, discussions. I thought maybe I might just first see if either of you had a question, comment, something you wanted to say, and then we could turn to the audience.
I have so many questions and things I want to say, but if I can ask Juan Manuel, I was appreciative that you pointed us back towards Butler and the distinction between legal performativity and bodily performativity. But I also think that you're doing something really productive and challenging that distinction almost through the conjunction of legal kinesthesia that is accounting for both at once. I'm wondering if you could articulate a little bit more of how you see those three terms in relation. You don't have to be tethered to Butler here, but just what you see that work of legal kinesthesia doing in those terms and maybe the risk or reward for doing so as it particularly relates to immigration law and your experiences thereof.
Yeah, so I mean, one of the things that has been motivating, obviously, a lot of this work is working as a presenter of artists who work in these spaces where folks are moving internationally or within the US and having to navigate how much information we say when we publicize when an individual is coming, but also doing petitions for visas. And often we find ourselves toggling in what Assad has called, engage or evade practices among immigrant communities, that folks use calculated movements for identifying when they disclose information. So disclosure, an important part, right, of how we attend to this information. And to your question about, sorry, this relates to my ongoing kind of negotiation that's specific to Latinx studies and immigration studies specifically, because much has been said about um, Jose Esteban Munoz and what he calls the brown commons, and thinking about how affect might be a primary mode of sort of working across difference. I'm unconvinced by that, given the strong imposition of the way in which I've worked with artists, specifically thinking about the way that they navigate visa petitions, naturalization. And so that tension has always been at the forefront for me. And with what you were saying about with the between difference between legal and bodily performativity, obviously for me, I see those as oscillating back and forth, and that's where this word of attunement that we're working towards, I think you and I think is important. This is still at the early stages of thinking about attunement, but in terms of the tension and the resolve of thinking about the legal and the corporeal, for me in the specific space of performance needs to be enunciated, because in dance studies, oftentimes performance and bodily performativity gets there's an elation over it, over like, oh, it supersedes difference, and I don't think that that is true. Um, and so this is why in a lot of the ways in which I'm thinking about it, in terms of you're saying legal kinesthesia, it's that summation. The possibilities that it offers for me is that on the one hand, it allows us to attend to, as I said through this presentation, and I argue throughout my book, the way in which specific laws do shape how we move across spaces, but that they're not also totalizing, right? They shape from state to state, from country to country, from jurisdiction to jurisdiction, and how we attend to how we create in specific environments. And that for me does the work of also identifying resistive practices or dislodgements, as Stuart Hall would call, where we're able to see radical tenderness, ludic encounters as a way to push against that. Um, but the downside, I think, is that oftentimes, and I have been critiqued by this by other colleagues who are formerly undocumented or undocumented scholars that I'm logging, that asking for an emphasis on legal specificity is reascribing the very same systems that include people. And I think that while that is true, I also think that we need formal structures for cohabitation across difference, right? I think to assume that, and this is where I'm not I don't subscribe to anarchic ways of understanding borderless worlds. I do think we need formal structures. And so I think being attentive to that and not losing sight of that is important to me. And legal kinesthesia gets towards that, towards understanding what type of structures and language do we use for cohabitation, for the protection of rights, because it is important, but also tending to the historical histories in which these laws that we have inherited are also sort of racialized, and how we do away with them.
It's really fascinating. Something else, if I might just uplift another observation that you've making me reflect on and just allow me to think out loud a bit here. Your work presents a really interesting oscillation, I'll use it again, if you'll permit, between dance as this illegal space, and we can think of dance bands. You use this example of I'd rather be caught working than dancing. And that kind of sits in a wider history and literatures of dance bands. We can think of Footloose as a cultural reference point. We can think of the scholarship of Kareem Kukanjani, who puts this more from a transnational perspective. But you also give us the instances of dance as the legal protection and sometimes legal like formality in terms of the profession, visa status, you're getting paid, you can prove you're here working, etc. And I just wanted to point you towards the case if this is interesting. One of the early loitering cases in 1960, I believe it's Thompson versus City of Louisville, is actually, and dance becomes the defense. Someone is kind of arrested for loitering and misconduct charges. And he says, no, 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 I wasn't loitering. I was on the dance floor. And it becomes his defense that he was dancing. So I just wanted to point towards the way in which dance is both the anxiety point and also the justification. And I think you give us shifting versions of that in really compelling ways. So it's not a question, it's a comment, but just sharing what you're asking me to think twice about now.
Yeah, no, thank you for that. And I obviously have responses for you as well, and I want to make sure that we also let folks who showed up to ask questions. So maybe if someone has a question for you, we can hear your space and sorry, hear your response to that as well. Anybody have a question for Anna?
Well, I had a question about vagrancy. Maybe it's a question for both of you, but maybe more specifically for Anna. It's to do with Sal Nicolaus's work on vagrancy. So I don't know if you're already familiar with that work. The reason why I thought it might be interesting. Sal published a book 2 or 3 years ago with Yale. It's called Vagrant Figures, and although it's on 17th and 18th century um, law and literature and culture, but and early 19th century. But one reason why I thought it might be interesting, given some of the points you've just raised, is that it's a book that's very interested in the ways that legal forms enable but don't determine um, movement, identity, attitude. So I thought among the reasons why it might be interesting is that it offers a fascinatingly historical dimension to the kind of argument that you just made about the importance of recognizing that law has a role here. It's not a determinative role, but it's also not to be ignored and oughtn't to be regarded as merely technical, say.
No, I appreciate that reminder, and I appreciate all the comments and offerings in the chat that people are putting forward. Saul's work in particular, that reminder of the historicity of where vagrancy comes from, I think gives more texture towards the language of productive or unproductive that I'm interested in. Um, I should return to his work, but I'm immediately thinking of like the 1866 Vagrancy Act, which is really a means of recapturing labor or kind of quote unquote cheap labor, recommodifying the body in a post antebellum moment. And so I think having that longer history is certainly relevant. I'm also appreciative of Risa Golubov's work that saturates it really in the 1960s and the diversity of reasons that loitering was employed for various kind of what she would argue, I think, political kind of spectrums of reasons that the body can be deemed out of place. And maybe what I want to call attention to in both of those work is that there's the historicity of it for the question of labor that has a long racial history in the US. There's the question of like what populations are being scrutinized by it. But underneath all of that, I think is really the question of what the still body is being perceived as, really what is happening. So not who is being policed or why, which is what I think their work really attends to, but what is really the gesture underneath that is being uh, transient in these cases.
Thanks. That's really helpful. If I could just also put in a plug for that article by Hannah Walzer. One reason why I think you might find it really interesting if you haven't already seen it is that it recapitulates very nicely the questions that you've raised about the ambiguity of performance from the perspective of the person who's being surveilled and the ways in which race is very important to that perspective. So ambiguity arises because you're asking yourself the question, what do I need to do to be seen as not loitering without intent?
Yeah, that's really fascinating. Thank you.
Simon, I have a question, but I still can't find the hand raise.
Please go for it.
Okay, great. So thank you both for absolutely brilliant papers. Really, really enjoyed them. I guess my question, I think relates really nicely to the discussion, the questions you raised, Anna, and then speaks to Simon's point about Sal's book. I was very much interested in whether or not you found, Anna, in any of your case studies, evidence that the use of performance or dance or the body to evade the law. So this kind of, gets at the questions we were just talking about. But I wonder, especially in the case of loitering or homelessness? Is there any possibility of capitalizing upon that kind of fluidity or creativity to evade what you rightly pointed out is just incredible ambiguity on the part of the law enforcement?
Yeah, that's a question that is really fascinating to me, and I intentionally carved out as I'm not addressing, in part because my expertise doesn't go there. That said, what I think is really put forward and comes to mind that I've been tempted to think with is turfing practices in Oakland in particular, as performance practices in a street or public setting that was meant as a way to be present without being able to be charged with being vagrant. Naomi Bragan is someone who writes about this with brilliancy, and as a result, I have not touched. That's also not my community. But I have thought a lot about street performance, including turfing, is really that claim to space and claim to visibility or reclamation of space and visibility in a way that feels salient. Claims to property rights undergird some of that practice. It's not, as you acknowledge, is not what I'm addressing here, but really that history is what comes to mind, maybe in part because of my own time in the Bay.
Yeah, no, that's very helpful. Thank you.
Yeah.
And just to maybe add one example as well that you might be interested in looking at,
Oh, thank
Melissa.
you. Yes, absolutely. I should have directed
There's also
question
another
to you as
work
well.
that there's also some of the more contemporary work because I've been working with these artists, but Tanya Guiniga does some of this work as well. For her, she's interested in sort of usurping the logics of the protection of public space through sort of the capitalization of parking spaces. And what she did for a bit is that she would go and put 25 cents on a park strip, which I think other artists have done this, but what she did is that she then sit on the road and she would essentially start knitting. She does a lot of textiles on the street and said, I'm not violating the law because technically the space is designed for the person who's paying for it. And she'd go through the city of Los Angeles paying 25 cents or 50 cents to quote unquote loiter within the protections of the fine of those little parking strips. That might be interesting. She doesn't necessarily
Yeah.
evasion there looks differently, right? It's evasion through the law rather than trying to be not noticed by the law. And essentially, she was intentionally calling recognition by the police and their documentation of her, the police showing up and saying, "Hey, you're loitering." She says, "No, I'm not loitering. I'm actually sitting here on a park strip. I paid the money to be here." And that might be an interesting case for you to look at.
That's great.
Really
Thank you.
interesting. Yeah. Also, the texture of knitting there as a lot to unpack as to what that craft and product is doing to have her read a particular way.
How are we on time, Simon? I have a question. I was wondering.
Yeah, we're doing just fine. Please fire away.
Yeah, and I have a question for you. That I think you mentioned this briefly, but I'd be curious to have you think about it largely because I'm also thinking about the way in which securitization has ebbed and flowed and how we think about, how spaces are protected under the lens of security models, right? Whether spatial segregation and the laws that get used to protect spaces either for leisure or also against loitering. And so I'm wondering if you can talk a little bit more about how securitization has manifested in the way that you look at it, but also how it perhaps, if you can speculate, how it has shifted and informed loitering, right, in the last couple of, even post 9/11. Largely I said because for me, an immigration discourse, looking at securitization along with immigration enforcement has now become hand in hand. But I'm wondering in your case, how have the logics or rhetorics of securitization informed these sort of the sites that you're describing?
Yeah, certainly it does. And I want to start by saying that I think on the first hand, my impulse originally was to think that it matters the perspective that you're coming from, like who is being secured and who is being protected, and who is receiving that protection and at whose risk. That seems to be the priority to me to unpack. That said, I often find myself challenged by assumptions when I do that work. For example, I made a kind of gesture towards what we might call hostile architectures, the kind of installations that we are familiar with that prevent unhoused populations from having access or easy access to flat spaces, really flat surfaces in which they could rest or lie down. And I saw that as one place of like, they're not receiving the security measure there. And I thought felt pretty clear on my understanding or my own ethics that like that seemed problematic. And then as I was trying to Google this for a different talk and I wanted an image of some version of hostile architecture, I saw that Boston had this newspaper and it said elderly friendly benches installed. And I thought, well, that's cool. And it's the same exact benches re-termed because they have additional armrests. So if you need assistance in standing, it is higher security and higher kind of health benefits that someone who's unhoused might see as actually invasive. So I point to that as a really small node, but a node in which my perceptions of who is being supported and who is being violated by security measures can also be subverted and challenged, and I try to remain open to. But I think that perspective shift is what I think we can do more nuance in naming who is receiving the benefit of security measures and who is the populations that is maybe taking some of the burden to produce that security measure.
Yeah, and
Yes,
partly
ugly laws in the chat. If people haven't read this, it's a space, it really important work, and also a space um, where aesthetics, ethics, and conduct, I think, come into really clear contention in public space. Yeah.
oh yeah, I do have a response to that, but maybe I'll wait and have Sean go ahead and ask the question.
Super, please.
Oh, no, Juan, you go ahead and respond, and then I'm happy to chime in after.
Oh, I think Anna and I will continue. Well, okay, I'll just be quick more. Just I think because I think working in the Bay, Anna, you may be familiar with Anna Tabor Smith's work on maybe
Yeah.
House Full of Black Women Resting. Are you
Yeah.
familiar with the project?
Yeah.
I was also thinking about what does it mean to signal security for protected individuals, right? Because in that case, there was a lot of public dissemination of this, what could be perceived as a performance, but it actively also enunciated its aim of a security while for the people who were actively going to participate. And I'm also wondering about that entering that signaling and enunciation of security that claims to create a space without necessarily naming individuals, right? That is not necessarily actively trying to evade all recognition, but also trying not to interrupt security industry, but rather exist in that space of saying we have mechanisms for that type of work that we do.
Yeah, absolutely. I'm happy to be reminded of Amar's work in a thinking along the same vein. I had a quote by Luke Williams who was reflecting on leisure, and he was actually writing a performance review of Amar's work when he made that statement. So, absolutely of the vein that I'm thinking with.
Sean, do you
Sean,
want?
please.
Yeah, sure. Firstly, apologies for not switching on my camera. It's the middle of the night in Australia here, and I'm still tucked up in bed, but I'm so glad I got the opportunity to tune in. Um, I was interested in this idea of choreographic attunements and particularly attuning through the body. I think in part because of the word itself, there's a natural inclination to think of attunement as a sonic act, listening in and the like. And I'm wondering if you had any reflections on how it is that we attune through the body. What is it that we're attuning to, and how can we think of attunement as a bodily practice in relation to law?
Juan, do you want to take that first? I want to uplift that as his suggestion for a title, and you kind of prompted me to think more deeply about it, but I think you should start as I want to acknowledge it was really your invitation to think with that brought me here.
Oh, yeah, no, thank you for that question, Sean. And I will say these frameworks are actually stemming also from talking with Anna and also another colleague, Michelle Castañeda, who has done excellent and brilliant work on immigration court systems and looking at the theatricality of those spaces and using performance studies frameworks and theater frameworks for understanding immigration court spaces. You're right, Sean, that attunement generally gets associated sort of with these sonic experiences, and I'm building again here on the work of Jose Esteban Munoz, the late performance studies and Latina studies scholar. And in his unfinished book, he leaves and sprinkled throughout a lot of his writings, he talks about attunement. And he talks about how performance itself and the social spaces it creates are spaces for cultivating an awareness of working across difference. But because the work is unfinished, I'm trying to articulate it myself as well, what it means, and applying it to the spaces of the law. Elsewhere, when I was writing about debilitated democracies, I talk about the way in which performance itself becomes a public space that connects the courts and also dance spaces, and offers this level of protection. But what it also does, it quite literally invites people to open up their senses, attentive to not just what we hear and what we see, but how we um, are felt to be made to feel when we're moving. And this is where Michelle's work is so important, where she talks about this immigration court system using the mise en scène, the overall total effect of what these constructed, the scenography does for how we enter spaces, because it's not just about the moment, but how when we leave in the moment, we're made to feel. So choreographic attunements to me is trying to figure out how we understand sort of what building on Diana Taylor's work on scenarios does, and what are these repertoires, right, that we inhabit and we recreate. And within immigration, I think they're very prevalent. Certainly, we have the scenarios and the repertoires of immigration enforcement at and border security at ports of entry. Right now, the way that ICE is entering. Um, and I see how a lot of the folks that I connect with and the artists that I write about, how they use performance not only to talk about those experiences and get a fuller understanding, but how attending to them in all the senses, through seeing, through hearing, through touch, might be a way to understand those experiences that are very oppressive and overwhelming at times. But as Simon says, they don't determine the space. They inform it, and how performance might be a way to quite literally construct other spaces where we might imagine ways of being otherwise assemble. I'll pause there and have Anna go ahead.
No, thank you, Sean, for that. And just for everyone, I want to uplift Sean's recent publication on human rights and in studies. A lovely title if you want to put it in the chat. It's a good article that I appreciated. But to the question of attunements, Juan Manuel's giving us a lot of things to think about. And I would just add to that that it's not only an I would say for my like somatic practice, attunement often means looking in, like a self-reflexive listening practice of what do you know because of X. And I would just invite that we also push it outward, that the law itself becomes more attuned, if you will, to the choreographic. I try to point towards this in the third case study I offered on encampments, the way that we're really have an attention towards free speech debates and less nuanced attention towards the choreographic moments of unrest that move underneath that, be it the right to assembly or be it encampments in this instance, but that we attune ourselves as much to the body as to scenes of like rhetorical analysis that we have. It seems there's more attention or more capacity to engage with in the public and in legal sectors on free speech than the right to assembly, etc. So I think that attunement is also from the point of those discerning a scene, not just those experiencing it. Certainly, we can learn from that internal attunement, but also just recentering the body as what we're really untangling through legal address, not just constructed.
Yeah, just to add to that, just one quick too. I think that's what's so compelling about what you're saying, Anna, in your work about loitering and sleeping, right? It's about how we read gestures. Obviously, there's an extensive work on the racialization of gestures, and I think we're indebted to that history, right? But where racialized gestures are linked up with a law, and how individuals who show up to enforce the laws have not only that history of those frameworks of looking at, but quite literally in the moment have to make decisions about how they respond to particular gestures, tone, movement, and collective being. I can only be reminded of just even here in our own campus, having been when there was encampments, um, and people certainly gather, and having the police arrive, that kind of gather in the outside, assessing the scene, quite literally looking intently, moving around. There's a level of calculus that is going on both on the demonstrators themselves, but also the individuals who are showing up and are whose role and responsibility is to ascertain how to best react, right, in that moment of actual bodies gathering. And what Anna describes of not just looking at what is being felt, but what is being seen and how that calls into specific actions is certainly, I think, in conversation about free speech, but even just ourselves right now, just to give an example, we're also trying to figure out how do we gather right now to have performances where individuals might not feel comfortable because of the way that might be read, or they might be compelled to be read by individuals who might then, call on certain authorities, right, to exercise a particular type of containment or detention.
Yeah, so if there aren't more questions, I think I will just thank everyone who came, and thanks to both of you for a wonderful and provocative set of papers. And I'm looking forward to reading more of your work. Uh, uh, thanks to everyone, and hoping to be in touch.
Thank you all.